All right, Madam Reporter, you ready?
I'm ready.
Okay. Oh, William Brown will need to unmute, please. Thank you. Good afternoon. This Judge Irvin will be on the record of the matter of the people versus Thomas Jerome Fox II, case number 22 CR 0038. May I have appearances, please?
Sandy Groven for the people.
All right, and Mr. Fox, are you able to hear me?
Yeah,
All right. Is your true name Thomas Jerome Fox II?
yep,
Is your birth date 9/14/1987?
yep,
Mr. Fox, I have a complaint. It's a one-count complaint that alleges that on or about May 11th, you were in possession of a sawed-off shotgun in violation of Penal Code Section 33215. It's a felony, carries with it 16 months, 2 years, or 3 years in prison, fine of up to $10,000 plus assessments.
yeah,
You're entitled to have an attorney represent you at all stages of the proceedings. If you cannot afford an attorney, the court can appoint one for you. At the end of the case, there could be a hearing to determine if you can pay back the county for the cost of the legal assistance. And if so, that would have the same force and effect as a civil judgment. You do have certain rights. I don't know if you've been furnished the rights form or not. You do have the right to a trial by jury, 12 members of the community, the right to cross-examine, the right to use subpoena power of the court, and also the right to remain silent. You also have the right to have a preliminary hearing within 10 court days or 60 calendar days of today's date. At that preliminary hearing, you through your counsel would be able to cross-examine a witness from the prosecution to determine whether or not there was sufficient cause for you to be held to answer these felony charges. If you were held to answer, you'd have the right to have your trial within 60 days of that date. Are you able to afford an attorney?
no,
All right. You'll be presented with a financial declaration that you can fill out after the hearing, but on the basis of your representation, I'm going to appoint Mr. Cooper, our public defender, who is present on the Zoom here now. Mr. Cooper, do you wish to accept the appointment?
Yes, I will, Your Honor. And hi, Tom. It's been a while.
hey, yeah,
Yeah. Okay, so you understand the charge that is been filed against you?
yep,
Okay. At this time, Your Honor, we're going to waive any further formal reading of the complaint advisement of rights. I would advise my client to enter a not guilty plea today.
nope, not guilty, yep, not guilty.
That's right. Okay, so we're on the same page. Not guilty. And then we need to talk about your custodial status.
All right. People want to be heard?
Yeah,
The people are not opposed to an OR release with conditions. Certainly search and test, no firearms and turn over all firearms. I also think that there was a question about a mental health referral as well as an APS referral.
all right,
All right. Ms. Gonzalez, did you have any input?
Your Honor, probation agrees with Madam District Attorney. We also would like Mr. Fox to participate in an investigation for the firearms relinquishment. That way we can figure out where that firearm that is outstanding is.
all right,
But do you understand what they're saying, Tom? They seized the weapon in question, but I think there's another firearm on the property, perhaps, that was noticed. So if you will cooperate with probation in terms of letting them know where these firearms are temporarily, they will be taken while we sort out the case. Okay. I
all
think
right,
it's best to be cooperative.
yeah,
Okay.
Okay, is there a waiver of the 10-day and the 60-day rule for
Yeah.
prelim?
Tom, excuse me, Tom, the next step in your case is what we call a preliminary hearing. You have no prior conviction, so you're probably not familiar with that, but it's a hearing where the people have a very low burden of proof, just showing a reasonable probability that you may have committed this crime. That is your next procedural step. You have a right to have that within 10 court days or 60 calendar days. And I believe the court is going to order you released on your own recognizance with some conditions. So I would advise you to go ahead and waive time for setting the preliminary hearing since you're not going to be in jail. Do you agree to do that today?
Yep,
Okay, thank you.
All right, is that both under the 10 and the 60 rule? Do you waive? both
It
of
is.
them?
It is, Your Honor.
yep.
Thank you. The court is going to enter a pretrial release order as follows. You agree to be under the supervision of the Sierra County Probation Department and shall obey all instructions given by said supervision officer. Report to probation immediately upon release from custody. Initial contact should be made by telephone by calling 530-289-3277. You shall attend all court hearings and interviews as directed, and at all times hereunder uphold and obey the laws of the state of California, the United States statutes and ordinances of all cities and localities where you reside. Not leave the state without permission from the supervision officer, and advise supervision officer within 24 hours of any change in residence or phone number. Notify supervision officer of any law enforcement contact within 24 hours of said contact. Required to sign a release of information to ensure compliance with any treatment, medication, other conditions imposed. Not possess, consume controlled substances and shall notify supervision officer within 72 hours of any controlled substance prescribed to you by a physician. Agree to submit to chemical testing of blood, urine for detection of drugs at the request of a peace officer or supervision officer. Type of test at the officer's discretion. Attend substance use disorder counseling as directed by supervision officer. Submit to chemical testing of blood, breath for detection of alcohol or drugs at the request of a peace officer or supervision officer. Submit person, residence, vehicle, property to search and seizure by any peace officer, or supervision officer at any time or day or night, with or without a warrant, with or without reasonable suspicion or probable cause. Not possess, use, or have under your control any firearm or dangerous weapon as defined under Penal Code 21-310. Defendant shall turn over any and all firearms to probation and participate in firearms relinquishment procedures with probation. The court will order a referral for mental health evaluation and adult protective services investigation. Sir, do you understand, accept those terms and conditions of your release?
What's that? I
Do you
don't
understand, do you understand those terms and conditions?
Yep,
Do you accept them?
yep,
All right. I've signed the order and you will be released forthwith, and you need to contact probation immediately. For the next hearing date, we would set for a pre-prelim on May 27th at 9 o'clock, and you'll be ordered to be present that date and time in court via Zoom or in person. You should confer with Mr. Cooper about what is the best thing for you under the circumstances.
If I could interject, Your Honor. So we have a little bit of a problem right up front. So I see on this probation report, it says no communication device. So you don't have a phone that,
no, but I can use my neighbors.
okay. Do you know what that number is, Tom?
Yeah,
What is it? 287 something?
no, it's 287.
Yeah.
30, what was it?
I'll tell you what, when you're released,
Yeah,
I hope that the Wayne Brown people will give you my phone number, which is 265-4565. That's really easy to remember. 265-4565. I want you to give me a call and let me know how I can reach you, because that's very important. And it will continue to be as we process this case, okay?
yep,
I don't want to lose track of you, all right?
yeah, no shit.
Okay, all right.
Yeah, all those, most of the guns I had were my grandpa's.
Okay, well, we won't get into the facts right now, but I just want to be able to reach you, okay?
All right,
Thanks, Tom.
That'll conclude things for Mr.
all right.
Fox right now. I have one more case to handle, a short one. This is the matter of Tessa Jackson and Brad Jackson, 21 FL 0041.
I'll bid you a good weekend this time, and I mean it. Thank you.
Bye, Mr. Cooper.
Good afternoon, folks.
Hi.
Matters on for a status conference. Anything you have to report to the court?
We're almost done. We've like agreed on everything and we have someone who's writing it all up for us and they're almost done.
Okay. Want me to set this out maybe 3 months and hopefully you'll have everything
We should
submitted
have
by then?
everything done before then.
Okay, let's pick a date, 3 months out, Madam Clerk. It could be on a Thursday with the normal family law calendar.
So August 11th?
August 11th at
Okay.
1:30.
Sure.
Okay, hopefully everything's submitted by then, because if it's
Yeah.
all submitted and the judgment's entered, then you don't
Yeah.
have to show up.
Okay.
All right, good luck. Thank you. Bye. That's it for my calendars until 3:30. Judge Buckley, it's all yours.
Judge Buckley, since we do have Wayne Brown still on the line, would you like to hear the Conway matter first? Oh, you're muted, Judge Buckley.
Are you hearing me now?
Yes, I can hear you now.
Okay.
Wayne Brown, is it possible to hear the Conway matter next? Wayne Brown?
Do we have Mr. Coonan?
Yes, hi, Judge Jeff Canan here.
Okay. Don't exceed the speed limit while you're in court, okay? That's
I'll try not to judge
it's a
it.
double citation.
If the court recalls,
Yeah.
I indicated I might be in front of Starbucks for this hearing. Here I am.
And we're awaiting the appearance of Mr. Conway.
That's what I'm hearing, I think. Before,
Apparently, he was shut down because of a COVID exposure.
well, we could proceed without him, I think.
Are we gonna try to reach him, Madam Clerk?
I can have the clerk's office call Wayne Brown. Are you wanting him to still be present for the hearing?
Yeah, if he's all set up to appear via Zoom, let's have him present.
Okay, just give me one moment and I will make a
Sure.
call.
Unless the sheriff's department was told that he was not going to appear.
I had requested it be by Zoom rather than live.
That's my understanding also.
Yes. And Judge, maybe just to do some calendaring work, it's my belief we're here on the 1368.
Correct.
I was going to submit it on the report in which Dr. Stembridge concludes that he is competent.
Could I share something with you if you don't tell anybody?
Sure.
I
We
did
are-
receive Stembridge's report. I remember reading it. I remember his conclusion. My wife had a bridge party a week ago. Now I can't find anything in my home study. So we could proceed with it because that's my understanding also. Ms. Groban, what is your position on the 1368?
We concur with Dr. Stembridge's opinion as to competency,
Okay,
and Mr. Canzaneri probably should better speak to that.
appreciate
Good
that.
afternoon, Your
You're
Honor.
not- You're not going to be referring to any part of his report and have some questions about it, I take it.
Correct, Judge.
That's correct, Your Honor. The people intend to encourage the court to follow Dr. Stembridge's conclusions and reinstate criminal proceedings.
And if I could
Yes.
just, I'm sorry.
Counsel, are you with the AG's office?
I am, Your Honor.
Okay.
And if I could just indicate that criminal proceedings were suspended pursuant to 1368 fairly shortly after the preliminary hearing. And so as soon as they are reinstated, assuming they will be today, I'm hoping to set this for a 995. Because I need to run one.
I was sent a carton of the file on Conway. His arraignment was on the charges was in January of 21. No, yeah, I mean, a long time ago.
On the original, well, the original charges. Is that?
No, on the arraignment on the information. When was that? Is that,
Perhaps Mr. Canzoneri's file is more excessive.
when did you declare a doubt?
We did the preliminary hearing in December of 2021. I believe the arraignment was earlier this year. in
I'm sorry, it was January of 2022.
Yes, Your Honor.
In
At
fact,
the election.
At that point, Mr. Coonan, is when you declared a doubt?
yes, I'm not sure was he actually arraigned before I declared the doubt?
I don't think he was arraigned on the felony information.
I don't think so either.
Okay.
I think we were on for arraignment when I declared the doubt.
Okay.
Correct. The preliminary hearing was held on December 2nd.
Yes. Yes. And then when we came back for arraignment, I want to say January 21st.
He was scheduled for arraignment on the information on December 16th is what I have.
I found those minutes now. So thank you.
Yes, And then I think he had suffered his injuries, his most recent injuries.
Correct, that's mentioned. The recent head injury matter was continued to January 21st.
For me to explore the potential consequences. And on the 21st is when I declared my doubts. And so he has not been arraigned yet.
I do not have a copy of the information. And he would need to be present for the arraignment.
He would. Perhaps we set a fairly short date for arraignment and setting of the 995.
I would like to take a few minutes to see if we can get his appearance on video. And if that fails, then we can set a short date.
And Your
Okay.
Honor, this is the court clerk. I just heard from the clerk's office. So Wayne Brown is, they started their court with Nevada County, so they're not sure when they can get Mr. Conway on video. And
You-
so
Okay,
It would probably be a good idea to give me an opportunity to talk. I have talked to him already about the arraignment, but it was some time ago. And it might be a good idea if I had an opportunity to talk to him further before we actually arraign him, if possible. And it would solve the problem of having to wait here for perhaps hours.
Can I make one other comment? With respect to submitting on the reports of Dr. Stembridge, I'm not sure, but Mr. Conway may want to be present for that as well.
That's true.
have you had a chance to talk to him about the competency finding?
I have talked to him since the competency finding. I would have to say yes, I have, such as it is with Mr. Conway.
I think it might be helpful, though, to have a waiver of his right to a trial, on a jury trial on the competency issue.
No, you're right, and I think he even has some rights if he disagrees with my position.
That's what I recall.
Yeah. So, but I would be prepared to arraign him if criminal proceedings are reinstated on that date, whatever date we pick.
So we can do both. We can have the 1368 review and we can also have the arraignment.
Yes, yes.
I'd be really interested in the defendant disagreeing that he's competent.
Well,
You're competent. No, I'm not. So how did you understand what I was talking about? Well, I'm not quite competent. Not likely to happen. But we do need to move along. This has dragged for a while now.
Yes.
Let's hear some suggested dates other than this coming Sunday morning.
I concur. I defer to the court's calendar.
If it's okay, I suppose. We should stay with a Friday, Madam Clerk?
Yes, Fridays at 1:30.
The 27th?
Judge, one of the,
May 27th.
Yes, of May.
Judge, one of the challenges is the court's preferred Friday dates appear to typically be every other Friday, which unfortunately corresponds to my every other Friday court calendar, which is what I had today. I happened to get out 25 minutes ago and come to Starbucks. It's not my preferred way to appear in court. If there's any chance it could be either a Friday that is not my prison date, like maybe the one after the 27th, or some other day of the week, Monday through Wednesday.
Well, and will we run into conflicts with Wayne Brown and Nevada County appearances if we continue doing things in the afternoon on Fridays?
Who is Brown?
And that's the name of the facility, Your Honor, that Mr. Conway is being currently housed at.
Okay. And Counselor, I didn't hear what you were saying about that.
Well, what I was concerned is if we have a conflict today with the jail that he's being housed at, setting up video conferencing for Nevada County's appearances, are we going to have a similar conflict if we continue this for another Friday afternoon? We will have the same problem where he won't be available because they're doing court for Nevada County at the same time.
I think with the assistance of our clerk, we can make sure that he's appearing and get confirmation of that.
Right.
Which everybody can be advised if there's going to be a problem. I don't see how that's not solvable.
Right.
I don't know how to accommodate Mr. Coonan's calendar, who's trying to accommodate the court's calendar, who's trying to accommodate my calendar, who's trying to accommodate Ms. Gomes' calendar, who's trying to cover, accommodations. Mr. Coonan, who's more important to you, us or the other people you have to go and see?
You, of course, Your Honor.
Thank you.
And that's why I'd like to be able to appear in a more professional manner.
Let's see, I'm looking at the next Friday would be the 27th. You're saying you'd prefer,
Well,
what, the 10th of June? I think we have to stay with the alternate Fridays.
so it could not be the 3rd of June?
Let's see, today's the 13th. Alternate would be the 27th. The next, if we have to skip a week each time, the next one would be the 10th.
But is the clerk suggesting that we do have to skip?
I don't know. I defer to the clerk. I know that they have their own schedule there for their reasons.
So my request would be the 3rd, if that's available to the court.
All right, I'm available on the 3rd.
We don't have anything currently set on the 3rd. It's not a normal court date for us. The only potential issue that we've been running into is getting a CSR scheduled.
Say the last part again.
We've been having issues getting a CSR scheduled, a court reporter.
We're struggling on that item too lately.
And my challenge is I lucked out today, but I can't schedule something when I
What
know
sort of commitments do you have on these Fridays?
a court. Today I had 14 cases, or yesterday, I guess today I had 10 cases. And with a lot of uncertainty as to when they get done. Sometimes they get done before 1:30, sometimes not till 5. And so I'm probably legally bound not to set hearings when I know I very well may have other hearings set at the same time.
Ms. Jackson, are you available on the 3rd of June?
I will not be, but somebody in my office may be able to. I'm not sure.
Can you confirm that now or not?
Now I cannot. No, there's nobody in the office.
Let's set it for the 3rd of June at 1:30. And we'll know by then or by next week whether somebody can be available to cover that from the Jackson's office. The answer is no, and we'll make other arrangements.
All right, thank you, Judge.
Thank you, Your Honor.
And time continues to be waived, correct?
Such as it needs to be, yes.
Okay, thank you.
Thank you.
Thank you, Your Honor.
And Your Honor, this is the court clerk. You want the defendant to be present via Zoom for that next hearing?
Absolutely.
Okay, thank you.
It's mandatory that he be present one way or the other.
And then we do have everyone on the line for the Stewart matter.
Okay, let me close some curtains here. I'm getting a sunshine through the window. Wow. Are you able to see my screen?
We can only see your background. Maybe if you try sitting closer to your camera.
No, you're talking to someone who knows nothing about it. So how do I make this my appearance smaller, like Miss Jackson's or Miss Grover's right now?
There is a little icon in the top right-hand corner and it says view.
Okay,
Click on that view, you can select gallery. And then you'll be able to see a
that's better.
square.
I'm seeing myself on a beach somewhere
You are.
and half my face. I don't know what's happened.
That's
You're here
okay,
in
too.
spirit anyway.
Ms. McGuire, you're a bit of a nerd. Can you help us out here?
No, I'm terrible.
Okay.
Sorry.
Well, I don't know what's happened to it. I really don't, but
Before you adjusted the window, you showed up much better.
really? Oh, yeah, for a while there
Yeah.
it was clear. Anyway, let's go with half a face. Is everybody present on Stewart?
Yes, Your Honor.
It appears my Susan McGuire for Ms. Stewart, who is also present on Zoom.
And
Yes.
where, I'm not seeing her.
I,
I'm here, Judge.
I hear your voice.
Yes, sir. Do you want me to switch over to camera?
Oh, you're not hooked up to the camera?
No, I'm fine with camera. I'm gonna switch over. Cause I called, the phone number.
Oh, I see. Okay, we're not gonna get to see you. All right.
Oh, I can do that.
I'm not even seeing the defendant's name. Is anybody?
I do see her name. It says Tanya Stewart.
I have judge's chair empty by the bench. I have the district attorney, I have Mr. Dwyer, I have Ms. Jackson. I have something called Sarah Court. Ms. McGuire, is Ms. Stewart appearing by phone or by video?
By phone.
Solely by
It looks-
phone.
Yeah, it looks like she was trying to get the video working, but it's not for some reason.
I was told that you are withdrawing your discovery motion. Is that correct?
Yes, Your Honor, and if I can briefly update you, and Ms. Groven can correct me if I've got anything wrong here. So we had 3 motions in the 20 CR 103 and 118 and 21 CR 10. So Ms. Groven had supplied everything I've requested, and except in the 20 CR 103, she indicates she is going to dismiss that case. So we didn't proceed with any further discovery. And then in the 22 CR 8, I did not have a motion filed in that one. And she has complied with all my informal discovery requests in that case. In the 21 CR 10, that was the 14601 case. She's awaiting what I requested from DMV. It's the abstract that shows knowledge or, service on the defendant. And so we're waiting on that one, but I don't have a problem dismissing based upon her representation. It's been requested and it's taking a while. And so it looks like in 20 CR 118 and 22 CR 8, those will be going ahead and setting jury trials. And, hopefully we can still work on resolving them in the interim, but at this time, I think it's time to move on to do that. And in the 14601 case, my client did indicate that she has paid a reinstatement fee to the DMV and is working on paying the insurance that's required. So, and I don't know the exact status of that, when the requirements with DMV, what was the situation with that? So I'm assuming that'll be all cleared up with what Ms. Groven is requesting from DMV.
So the record can reflect that you withdrawing your motion for discovery on those where you filed the motion. Discovery is,
Yes.
You're satisfied with the discovery on 0010, 14601.
Yes.
And which one do we want to set for trial first?
The oldest one probably, which is the DUI case 20 CR 118, I think it's 0118.
It is.
I've indicated to Ms. Groven that I intend to call an expert, and I'm not sure why I'm having some difficulty reaching the expert that I've typically used, drug detection laboratories. So I've requested it be set out just a little ways. Let's see, we're either the end of June or into July.
Is this a driving under the influence of alcohol or drugs?
Yes, alcohol.
And you're looking for an expert on what?
Just the toxicologist. And I've contacted them in several fashions, but I haven't heard back, which is strange. So
Was there a
I
blood
attempted-
taken here or a breathalyzer?
it was breath.
Say again?
It was breath.
And what was the reading?
The 1.6, Your
No.
Honor.
1.7?
Oh, thank you.
1.6.
1.6. Ms. Groven, have you perhaps checked the availability of your arresting officers and also the expert on the breathalyzer?
The expert on the breathalyzer is available whenever we are. The investigating officer is available whenever we are as well.
Is he local or CHP?
CHP for the DUI.
Okay.
The only difficulty that we're going to have is for trials. We've got a trial scheduled for June 1st. We've got one for June 14th, and then we have one in August. Well,
So
the one
you
in
want-
August isn't me, so I don't care. Oh, yeah, early August is another trial.
So you're saying we should go second part of June? We're available end of June through up to August? In July, is that what you suggested?
July.
Is there a June date, Ms. Groven? Ms. Groven?
No, we've got 2 trials in June, so that wouldn't work, but we could do July probably.
Mhm. That would work with me as well. I'm assuming Ms. Stewart.
Yes, thank you.
And you begin your jury trials on Tuesdays or what day of the week?
We generally start jury trials on a Tuesday and go for that week.
And we have to go into July. We don't have the last few days of June available.
That would be a question for the clerk. You know, we have some issues with jury trials in Sierra County. We have 3,000 residents and not all of them are eligible for jury duty. And I guess we will cross that bridge when we get there, but I don't know if Madam Clerk has dates in the end of June that would work.
And Your Honor, based upon the issues I'm having with actually connecting with my expert, my preference, I guess, would be July, if we can do it, if it works for anyone else.
And Your Honor, this is the court clerk. We have the week of July 11th completely open, and we have the week of July 25th, which is also completely open.
I'm seeing that July 12th is the Tuesday, correct?
That's correct.
Let's set it for that
Yeah.
date. What time?
That sounds good.
Thank you.
What time on June 12th, July 12th?
Do you want to start at 8:30?
No. You want to give me another number?
9?
9 works.
Okay.
July 12th at 9 a.m. Do we do a trial confirmation?
Yes.
Your Honor, do you want to set the trial confirmation for June 21st, June 24th at 1:30?
Oh, June 24. Is that the same date we're coming back on Conway?
No, Your Honor.
Can you give me that, please? I haven't written it down. Is that
I believe we set Mr. Conway for June 3rd.
June 3rd?
Mhm.
I show that I'm appearing in your county on June 21st.
That's a Tuesday. Would you like
Correct.
me to put it on the calendar then?
If it's doable, I don't want to have a 5-minute hearing. I mean, the background on this is I appear in your county for half an hour. And I spoke to the judicial council about it. I would like to bill half a day. They don't do that anymore. So it's all or nothing. And you might tell Jean Ann Cheatham this. On August 25th, I believe was the date. No, not August at all. March or April. I had an appearance in the morning in your county and an appearance, I knowingly did this, had an appearance in Colusa County. And I chose to stick Colusa County with the bill. So I will let her know because I'm asking you to remember some detail here, Madam Clerk. She has sent me, reminded me I did not make a claim for that particular day, and I'm not going to. But background of saying I prefer to have it on calendar when I'm already going to be there. So if it works for everyone, then we should do it on.
And I did find, so you were right about June 21st. I have you on in the morning at 9 a.m. It's for a proof or a peer, but we do have you on calendar then. Would you like to set it at the same time?
Yes, let's do that, okay?
That works for me.
And what is the matter that I have on calendar already on June 21st?
It's People versus Michael Lee Hertzberg for a proof or a peer.
Say the name again.
Michael Lee Hertzberg. He's supposed to show proof of completion of DUI class.
Oh, that's right. I didn't think it was a big deal. Okay, let's aim at doing it on June 21st, trial confirmation. Ms. McGuire, you would have consulted your expert by then. You would know whether you want to proceed with an expert or without him, or whether you want to throw yourself on the mercy of the court and have your client plead guilty with a 0.16. I get
Okay.
the sense that Ms. Stewart would not agree if the sun was shining. So I would like you to talk to her bluntly. If there's no defense, let's move on. Let's be realistic here.
Exactly.
I'm particularly non-excited about a 14601.
Oh,
and I'm sure Ms. Groveman
yeah.
doesn't really care about that one either. Especially if she's making arrangements to get her license. So we could take that one.
I don't care for the.
We could take that one off the Stewart calendar at some point.
I'll keep the DA informed of the status on that in the interim as well. And in any
the other-
event, that if.
What about the other cases? The one,
The
69, I think?
Yeah, there was the 69, so I'm assuming when we're done with this trial, we can set that one, or, you know, we'll see if we can resolve any of these cases, of course. I'll continue as we have the discovery and discussions with my client and further investigation.
Okay, so June 21st, we're
and
gonna
my
talk about, we're gonna confirm whether the DUI is going to trial. And we're gonna discuss the other cases. They're on calendar for further setting, correct? Is that
Yes.
one way to describe it?
That would be the best way to describe it.
And time is waived on all matters.
Yes, and my understanding is, and I don't know if the district attorney is interested in doing it today, but I dropped my motion on 20 CR 103. That was a 422 case. She indicated she's going to be dismissing that. I don't know if we want to just deal with that now and take it
Sure.
off calendar
Remind me
altogether.
which case you're talking about?
It's 20 CR 0103. It's a 420 true criminal threats matter.
Involving citizens with restraining orders?
They had stay away orders, yes, Your Honor.
Stay away
and-
orders, yeah.
And they are aware that my intent is to dismiss.
And I'm looking at the printed calendar right now, 20 CR 0103. You wish to dismiss that now? Ms. Gordon?
Yes, I can dismiss that now, Your Honor.
So ordered. So that leaves the driving under the influence, which is set for trial and trial confirmation. Also, it leaves 14601.
Which we anticipate that's going to resolve most likely one way or the other. And my client is doing what's necessary to, you know, I'll be able to report to Ms. Groven if she's gotten her license back. And see if we can
we
resolve that.
have the PC 69, the most recent matter.
Yes. And we'll discuss that on the 21st of June.
Keep
And what
working
time
on
was that
some,
gonna be?
keep working on getting some disposition by agreement here.
Mhm.
In essence, Ms. Stewart is accused of kicking the police officer, correct? Backwards.
That
in the
is correct.
snow with no shoes. She either kicked him or she didn't. Unless she wants to say she was incompetent. And we'll send her to Stembridge if we have to. Okay. Madam Clerk, please keep me apprised of everything. I'm not sure my note taking is the best. We're going to hear from the court reporter as to whether somebody's available to cover Conway. Hoping for that. I've written down the dates. So, is there anything further at this point?
I had one question, Your Honor, just to clean up my minutes. What's the time estimate for the jury trial?
2 days, is that?
District Attorney has 2 witnesses in all likelihood, and then, so you're saying 2 days? Is that what you
Usually it's
suggested, Mr.
about
Wall?
half a day to pick a jury, right? And so that should be about right.
2 days, Madam Clerk.
Thank you.
No zooming.
You said no Zoom, Your Honor?
No Zoom.
Okay, thank you.
I
Now,
can't imagine what it's
just on
like
that-
doing a jury trial via Zoom.
Just on that one, I'm not sure what the district attorney's position is, but the driving was observed by independent witnesses, allegedly not the officers. So,
Okay, so maybe more than just a couple of witnesses.
yeah.
Okay. 2 days should cover it.
Okay. Yeah, That's a safe assumption, I think.
What's the likelihood of getting a court reporter, Madam Clerk?
I will send an email when I get out of court today. And I will get one for June 3rd, and I will also get one on the books for the jury trial as well.
I think Ms. Cheatham sent me that email concerning the difficulty of getting court reporters. I shared that thought with the Sutter County court reporter, who's independent, and she confirmed it. She said it's becoming very difficult.
Mhm.
So I don't know. It's brings us to a standstill if we can't get court reporting coverage.
Yeah,
All right, folks, thank you.
thank you.
Judge Buckley.
Ms. Groven?
Yes.
I've noticed the AG's office appears on some of these cases also. Is that